The worst case I've ever seen. As a result of the jury's decision to sentence the perpetrator to life in prison, the family members of a mother and daughter who were brutally killed in 2018 were present in the courtroom when a judge handed down 3 consecutive life sentences. A term of life in prison without the chance of parole was agreed upon by the jury for Ronnie Oneal, who was found guilty of murdering his girlfriend and their daughter, who was 9 years old, as well as attempting to kill his son, who was 8 years old, at their house in Riverview. The punishment was handed down approximately 1 month ago. He was accused of murder, and his son testified against him throughout the trial. An emotional statement was made by the victim's family before the sentencing that was scheduled to take place by Judge Michelle Sisco. According to Carrie Lloyd, Kenyatta Barron's mother, Oneal abducted angels from the family, including his daughter, Ron Oneal, who had severe difficulties and was unable to communicate verbally during her childhood. Lloyd stated that she was dissatisfied with the result that the jury had reached and that she desired Oneal to be sentenced to death. In addition, she stated that Oneal made a mockery of the judicial system by defending himself in the trial for the double murder and screaming before the jury. Additionally, she stated that Oneal blamed Barron for the murders on the defendant. A significant portion of Lloyd's testimony was spent in tears. After that, Oneal, who was handcuffed and wearing a red inmate jumpsuit, stood up to make his statement. When he turned to look at Lloyd, he shifted his attention to the gallery and stated that he would not apologize for his actions. He started quietly, saying, "I'm not sorry for something I didn't do," and then he raised his voice to shout, "And I am not sorry for the things I did do." The judge reprimanded him for his tone and warned Oneal that she would have him removed from the courtroom if he continued to rant. In the following sentence, he said, "But I will say that I am sorry for your loss." He then lowered his voice once again. Without having any knowledge of the actual circumstances, everyone is eager to point fingers and play a blame game. At the time when Judge Sisco was delivering his sentence, she ordered Oneal to rise and face them. 19 years I've been at this job. I've seen human beings killed at the hands of others in every way imaginable, she stated in her statement. This is the worst case I've ever seen as far as the facts go. In his memory, Sisco recalled the statement of a firefighter who had carried the body of Ron Oneal, who was 9 years old, out of the house. When the person from the fire department testified and said he retrieved the body of Ron Oneal from the home, and all he could do was sob, it took every ounce I had not to start sobbing too, because there's no way any person with any feeling could have witnessed or seen the photos of what occurred that night and not be haunted for the rest of your life. The judge was quoted as saying, "I know I will be. For the rest of my life, I will be haunted by what I saw as far as the evidence, and just the abject cruelty of it all." Sisco devoted a significant portion of her concentration to uncovering the specifics behind Ron Oneal's passing. It was alleged by the prosecution that Oneal murdered his daughter with a hatchet. The victim was born with difficulties and was unable to communicate verbally. She couldn't scream, she couldn't run away, she witnessed what you did to her mother. Sisco remarked to Oneal straight in the courtroom. She couldn't run away, she couldn't say anything. She had already experienced a childhood in which she was born with problems, both in terms of her physical and mental limitations, and she was aware of the agony that the child had to endure. It is indescribable to think about the anguish and distress that she endured as a result of your actions that night. During her description of the moment the young girl passed away, the judge seemed to become visibly distraught. That child knew that she was being betrayed in the cruelest, most tragic, and most sorrowful way that a child could ever be betrayed. At that moment, when you struck her with that hatchet for the first time, and little Ronnie testified that all he could see was tears coming out of his sister's face, she knew that she was being betrayed. She was being betrayed by her parent, the one person who ought to be there to protect their children, love them, and keep them from harm. Sisco said, her voice tinged with wrath. She was being betrayed by her parent, and that was the last thing that child felt before she passed on from this earth was your utter cruel betrayal to her. After that, she delivered her sentence, which consisted of 3 consecutive life terms, without the possibility of release for the 2 murder counts, and the 1 attempted murder charge. She then handed down a sentence of 30 years for the crime of arson, as well as 30 years for each of the 2 accusations of aggravated child abuse, for a total of 90 years in addition to the life sentences received by Oneal. A motion that was submitted on Oneal's behalf, demanding a new trial, was denied by the judge before the judge decided whether or not to adopt the recommended sentence that was imposed by the jury. The ability to testify in court was allegedly denied to Oneal, according to his claim. It was the defense counsel who was assigned to Oneal for the penalty phase of his trial who was responsible for drafting the motion. During his trial, Oneal acted as his attorney and represented himself in court. He occasionally yelled at the jurors as he developed a defense plan to counteract the upsetting facts and testimony of witnesses. During the closing statements, a public lawyer who had been appointed to participate in the case requested the jury to spare Oneal and instead sentence him to life in prison. A psychological expert testified during the sentencing phase that Oneal was diagnosed with post-traumatic stress disorder (PTSD) as well as delusional disorder. Just a few months before the killings, Oneal's mother spoke to the jury about a random drive-by shooting that came dangerously close to taking her son's life. However, she chose to conceal her name throughout the testimony. Indeed, at least one juror did not vote in favor of the death penalty. On the other hand, in the state of Florida, jurors are required to reach a unanimous verdict to recommend the death penalty. After 3 years of preparation, the trial finally began in 2018, and after only a few hours of deliberation, a jury decided that Ronnie Oneal was responsible for the horrible murders of his daughter, who was 9 years old, and the mother of his 2 children. His son barely made it through the assault, but he was able to survive and testify against his father when he was 11 years old. With 2 counts of first-degree murder and 1 count of attempted first-degree murder, the jury decided that Oneal was guilty of all charges. In addition to that, he was found guilty of resisting an officer without resorting to violence, 2 charges of aggravated child abuse, and arson respectively. Oneal remained silent and did not appear to react when the jury foreman read the judgment at 7 o'clock in the evening, which was slightly more than 4 hours after the beginning of the deliberations. The judge, Michelle Sisco, praised Oneal for his effective defense after the jurors had left the room on Monday evening. However, she also encouraged Oneal to consider the possibility of letting a state-appointed attorney take over for the subsequent part of the case. As you are aware, it does not get any more serious for any defendant in any criminal courtroom in this country than what you are facing now, she warned Oneal, who slowly shook his head in agreement. I'm going to strongly encourage you to consider allowing counsel to now step in and represent you. That's about all. If you enjoyed this video, make sure to subscribe for more. Hit that notification bell so you never miss an upload. Feel free to like and share, and I'll catch you in the next one.